All right. Hello, everyone. Thank you so much for joining our webinar today. My name is Mary Castillo. I'm a marketing coordinator here at LexisNexis Canada, and I welcome you to the Justice Adapting the Alberta Courts webinar. As COVID-19 events continue to unfold, LexisNexis Canada is working to support the legal community by providing free legal news, analysis, and other key resources specifically geared to support your decision-making and counsel on COVID-19 matters. The LexisNexis coronavirus landing page provides a document kit that can be downloaded for free. Existing Lexis Practice Advisor customers can access this information within the product through the COVID-19 pod. Feel free to access this content at lexisnexis.ca/COVID-19. So today's webinar will now begin. I'd like to introduce the moderator for today, Felix Evans, a LexisNexis Practice Area Consultant.
Thank you, Mary. Hi, everyone, and welcome to the LexisNexis COVID-19 Justice Adapting webinar series for the Alberta courts. I'm Felix Evans, and I'm the moderator for today's panel discussion. I'll keep this introduction very brief. This webinar is part of a series of discussions LexisNexis has been presenting across Canada to bring the legal community together in sharing updates and information about how lawyers, the law societies, and the courts are adapting to the pandemic. And today we're fortunate enough to have with us on our panel the Honourable Justice Khular of the Court of Appeal, the Honourable Chief Justice Moreau of the Court of Queen's Bench, and the Honourable Deputy Chief Judge McLellan of the Provincial Court. I'm certain everyone listening already recognizes the unprecedented impact this pandemic has had on our justice system. We also recognize the situation continues to change and the information we have is in flux. We believe open lines of communication within the legal community are key to ensuring the justice system and its participants remain resilient and adaptive to the challenges ahead. And we therefore hugely appreciate the panelists taking the time to join us today. And I'd just like to extend thanks from myself and everyone on the webinar and the entire team and the entire company of LexisNexis Canada. So thank you very much for joining us. The format of our panel discussion will take the form of a question I will ask to the panel and then invite each justice to weigh in on that issue. So you won't have to hear too much more of me. The chat is open if you would like to ask any questions. As we do have pre-planned questions, we can't promise that we will definitely have the time to answer these. Many of them may be answered during the course of the discussion. If we do have time, we will try to select some at the end. So with that, I will start with our first question. And if we could start, I think, with Justice Khular. And the first question for the audience is, what is the general experience since the start of the COVID-19 crisis for your level of court? Thank you.
Thank you. There's a number of points I think I'd like to make, and just to recall where we started. Friday, March 13th was the last day of regular sittings for our court. And on that Sunday, the government announced that all schooling would be canceled, and then we were into a public emergency by declaration by March 17th. And like everyone, the court initially struggled with what to make of this pandemic and how do we protect the safety, public health and safety of everyone who comes to the courts, the public, the judges, the staff, court staff, and struggling. Early on, we made the decision that we would try to continue to operate electronically or virtually. And we made those announcements to the profession. We're able to do this for a few reasons. One, given the nature of the appeal work, first of all, some appeals and applications can be heard in writing if the parties consent. And that has happened, though not a lot of uptake on that option, but some. Second, the Court of Appeal, we're just dealing with legal argument from counsel. We don't have to deal with witnesses and the challenges the trial courts have to. And the third thing that enabled us to move quickly to the virtual hearings is our court record system, our Court of Appeal Management System we call CAMS, it was a digitization project. So our court records were essentially all digital, that anybody could access this, everything electronically on the court record, no matter where they were. So we moved very quickly to work from home for staff and judges, and we were more easily able to adapt to virtual hearings. We had our first audio conference hearing within a week of the pandemic, and we had our first Webex virtual video hearing on March 30th of this year. One of the challenges, we were doing all of this and converting to doing virtual hearings while we were still operating at full bore. We never stopped operating. But with the assistance of the staff and the countless extra hours they put in, we were able to get the new system up and running. And just in terms of how it's worked, it's interesting how the bar has adapted. In the first few weeks of sittings, we were getting a lot of requests for what we call COVID-related adjournments. Maybe 30 to 40% of matters were adjourning. But by the end of April, beginning of May, we were back to almost normal operations, no COVID-related adjournments, just normal, typical of adjournments. And of the matters that have been adjourned, about 98% of them were rescheduled right away. So at this stage, we've managed to operate continuously, and at this stage, we're almost back into what everyone calls the new normal.
Thank you very much. And I'll pose the same question to Justice Moreau, please, about the general experience for your level of court.
Well, I have to say it was far different from the Court of Appeal. And as everyone who's on the call knows, we had a great challenge ahead of us because our court is, like the Provincial Court, a court of record. So every court proceeding needs to be recorded, and that happens in our context in the courtroom. We also have live witnesses in our trials. Very few matters go ahead to trial with pure argument. That would be done in another context, probably in a special chambers hearing. So we had a dramatic change to our daily work from the get-go, from March 16th, when the first master order from our court was signed by me to essentially stop all sittings that were not urgent or emergency matters. And so that meant jury selections, jury trials, regular trials in all areas of the law. And we developed very quickly a triage system so that people could continue to access the court as an essential service to deal with emergency matters like bail reviews, like emergency protection orders and emergency matters, for example, in the commercial context, civil context, Anton Pillar orders, those sorts of situations. And we made those announcements in writing. So thank goodness we had our website revamped about a couple of years ago so it could handle the traffic that we put onto it in very short time. And we did so by way of orders. So we're up to 4 master orders by now. And we had the use of announcements for those matters that we were making more substantive and long-term changes on. We did that by way of notice to the profession. It's been a time of rapid advancement for us, whereas the Court of Appeal, I'd say, was about 90 to 95% from what I have heard digitalized, and were really much more ready than the trial courts. I can say that we had been requesting for some time, certainly since the beginning of my administration in October of 2017, for the badly needed IT renovation for our court in order to get into the 21st century. And I'm happy to report that that has occurred in the sense that I would say that we have technologically progressed in the last 8 or 9 weeks, probably over 4 or 5 decades of work. The ministry is assisting with resourcing our transformation to an IT savvy court. But as you can expect, that's going to take a little bit of time. We converted to email filing to assist the public and lawyers in terms of having access to our court system and our court level, where they could not have easy access to our courthouses physically. It was a catalyst, the pandemic, to look at remote hearings, much as the Court of Appeal has done through the Webex system. But in our case, we do have to connect those hearings in most cases to a courtroom. Where we decided not to worry about a courtroom, where we're with respect to processes where we did not previously record in a courtroom. And so we've been offering up judicial dispute resolutions by Webex, in the criminal context, criminal pretrial conferences. And I think the figure as at May 31 was that we had done 415 criminal pretrial conferences across the province in an effort to determine whether trials that had been canceled in the criminal realm could be resolved. Opened up summary disposition courts to take guilty pleas if the bar was interested in resolving matters and having them finalized. We also moved to in-writing applications. We're hoping the uptake from the bar is considerable. As of this week, we have, in fact, as of yesterday, opened master's chambers for a more regular activity and our civil justice chambers. And we are offering up the ability to have the special hearings that are usually done with written submissions in any event, but done fully in writing. And of course, everything else will be by Webex hearing. The reason for that is we don't want to return to where we were before with in-person hearings being canceled, adjourned, and creating this huge backlog. We want to move forward, and in moving forward, anticipate that there may be further waves of COVID, and we do not want to be in the position of shutting down the way we had to our more routine matters. So the experience has been not without its frustration, not like private business. We don't have takeout service. We don't have deliveries. Everything occurs within the courthouse. And so what we needed to do is move that courthouse into a remote world. And we're gratified, of course, that we're able to do more and more, and hoping, obviously, to return to that new normal that was just described earlier.
Thank you so much. And finally, the same question on general experience for your level of court to Judge McLellan, please.
Thank you, Felix. We appreciate the opportunity to discuss where the court is in dealing with COVID-19 and where we hope to go over the next few weeks and months. I won't talk in great detail about some of the technology that we're implementing or trying to use, as that will come up in later questions. I will say that the Alberta Provincial Court sits in 71 locations and has about 167 judges and 35 justices of the peace. The disruption and necessity of change in the day-to-day operations of our court was immediately apparent when the crisis struck, and much along the lines of what Justice Khular has talked about. Our top priority was to initially create a pandemic response plan to maintain reasonable access to justice and provide the court's most essential services, while at the same time trying to maintain the health and safety of our staff, judicial officers, and the general public. We've relied upon the advice of Alberta Health Services when deciding what steps to take. We closed circuit points, leaving 21 base courts to handle urgent and emergency applications. Chief and counsel in our court consists of a chief judge, deputy chief, 9 assistant chief judges from various areas of the province in various jurisdictions. The executive director of our court, executive legal counsel, and executive director of court operations met daily, and sometimes more often, to collaborate to build the pandemic plan. And that's all in the face of early uncertainty. What we learned is that a strong working relationship developed with chief and counsel and expanded to many stakeholders, including resolution court administration services, sheriffs, crown and defense lawyers, legal aid, corrections, and others, to formulate new processes and procedures, much like Justice Moreau has talked about and Justice Khular, either via telephone, electronically, or by video conferencing. Although this has been challenging, and I will have a theme, as our court had dated technology infrastructure. So technology has been challenging. You will hear me say that perhaps more than once. Given the uncertainty and the changing face of the virus, planning's been stressful, demanding, frustrating, but it has been amazing because all the players in the justice system are working together. Even the courts, all the courts are working together. Courts are an essential service. Prompt change was needed in our court. Calgary Criminal Court, for example, combined 27 criminal courtrooms into 6 courtrooms with remote appearances. But the work of the court has to continue, so urgent matters, much like Justice Moreau talked about, were triaged, processes developed, and many matters were adjourned to the day we can safely return to business. We're well aware that that may involve backlogs and a surge, and we're working hard to try and manage those problems. The Provincial Court website is updated regularly, and this will be another one of my themes, that it's important to look at the website for practice notes, procedures. They've changed since March 17th to the present, and we're moving forward as time goes on. So information on the website is very important. We have practice notes, directives, and 2 rules. And a lot of that work required legal analysis, consultation with the bench and our partners, and work with IT. And later on, I'll certainly speak with the changes we made. We are certainly far from the new normal that Justice Khular has talked about, and certainly closer to the position of Justice Moreau. So I'm going to say, as an opening remark, our experience shows a stressful, fearful time. It was met with hard work and dedication by many people, including judges, and it highlights the need for technology and innovation. There's my theme again. Our court's experience reflects the need to change in a way we never imagined, and in a manner that considers so many justice participants. Thank you.
Thank you very much, Judge McLellan. And if I may, I'll stay with you for the second question, which is related. And this is just, did your court already have measures in place for virtual hearings, or your level of court, sorry, or were there projects in progress to offer this kind of technology and measures for hearings in the future that perhaps were speeded up?
Okay. Thank you, Felix. Our court had very limited measures in place for virtual hearings, and those measures were insufficient during the COVID crisis to use for the large provincial workload in our criminal, family, and civil divisions. The justices of the peace in the Calgary and Edmonton hearing offices hear all first appearance bail in Alberta virtually. The justice of the peace, Crown, and legal aid lawyers all appear on video screens, and the accused is often on a video screen as well if they are in a law enforcement arrest center that has video capability, or they come in by telephone. Private defense lawyers may also join by telephone. This was a valuable project that was developed over the last 4 years to improve first appearance bail, and that work continues. Justices of the peace and judges have also dealt with telewarrants, and those are warrants that are applied for by telephone or other means of telecommunication. So that continues and certainly was in place. In the family courts, youth in secure treatment facilities and at the young offender centers were already having hearings by CCTV or telephone. Child apprehension, some emergency protection order applications were held by telephone in provincial court or through the justices of the peace. And I never thought I would say this as a positive. As a result of the 2011 Slave Lake fire, 2013 flood in Calgary, and the 2016 Fort McMurray fire, our court had some experience in the transfer of matters from one location to another and the use of CCTV and telephone hearings. Edmonton Criminal Court had a remote motions court. That was a phone-in court. Interestingly enough, it was rarely used. The courts, our courts, as well as certainly the other courts, have had some experience with witnesses testifying virtually from child witness rooms or experts from out of town. In short, however, my theme again, we did not have enough technology measures and projects to immediately move to sufficient virtual measures to deal with the crisis. Some phones in some court locations did not have multi-party capacity, so we've worked to improve that. The pandemic has highlighted the need for technology innovation, and I will say all the collaboration is working towards improving that, and maybe someday we'll be at the new normal.
Thank you. Thank you very much. Thank you very much. And the same question, please, to Justice Khular around any measures in place for virtual hearings or whether plans were expedited.
Sure. In this regard, I think we were caught pretty flat-footed, quite frankly, while we used CCTV for some appearances for people who are in remand or in different institutions. Really, all we had was we had a video capability between our two cities. Half our court is in Edmonton and half is in Calgary. And our courtrooms were connected, but it was premised on people being physically present in the courtroom. So a judge could be sitting in Edmonton and counsel could be in Calgary, and you could hear the matter. We have found, for instance, by moving to Webex, that technology is not compatible with Webex. It had caused problems. And one of the challenges with the new technology is every set of hearings, we find out about new problems we have. It's like whack-a-mole. You think you solve something and another problem appears. So the provincial court, I think, or the government of Alberta had just licensed Webex and was starting to look at it. And that's why we're working with that platform.
Thank you. Thank you very much. And the same question to Justice Moreau, please.
Well, I think that I certainly don't want to repeat the comments that my colleagues have made, because our experience is very similar to that of provincial court in essentially being at the starting gate for a video conferencing and those sorts of things. We were really not down the path at all before the pandemic struck. I think what I can say is we heard the odd specialist or expert witness by video conferencing through an order that would be granted to permit that to happen. We had accused persons attending court through CCTV remotely. And I think that would about summarize, apart from perhaps master's hearings in some of our regions being held by telephone as opposed to Webex. So we have graduated very quickly to the Webex hearing, and we chose Webex because it could be integrated with our Cisco video conferencing products, those that we had at the time, and allow us to get moving very quickly. And as I said, that integration had to happen because we're a court of record. That's caused some hiccups along the way, working very closely with Resolution Court Administration Services, the IT sector, and the ministry has been very cooperative in moving us along to where we need to be remotely. And I think really that's all I would have to say about that.
Thank you very much. And for the next question, I think we have touched, the next question was around implementing new software and technology. I think we have touched on that a little bit already around Webex and enhanced Cisco services and so on. So perhaps I will move on and we'll combine the fourth and the third questions. And I'll stay with you, Justice Moreau, if I may, and just ask you to share the experience of your court working with administrative services remotely, research and research services with the physical libraries being closed. And then if you wanted to add any additional comments on any other software and technology, of course. Thank you.
Right. Well, if I take your question to be how are we working to move ahead with the administrative branch of the court, because we have Queen's Bench Judicial, Queen's Bench Administrative, that is the province of the Ministry of Justice. We are working very well at this point, right away after the pandemic struck and the master order was signed by me on March 16th. And of course, you've heard from other courts about the stand down in terms of access to the courthouses. We started meeting, it was actually daily for a while in a scrum with the ministry folks. But that also included elements from infrastructure, the correction service, from prosecutors, et cetera. We had a defense organization, and then we kind of narrowed the focus to deal with our daily issues. The meetings got a little bit less frequent over time. There was an overall meeting that occurred at least once a week between the three chiefs of the three court levels with the Minister of Justice, the Deputy Minister of Justice, and the ADM and ADM in charge of court services. And so we could bring to that table any issue that we had that was coming up. And I got to tell you, it got pretty detailed, pretty specific, but those meetings allowed us to move the discussion on to action, and I think have been very useful. In fact, we won't let them go. And we continue to meet with the minister. I think we're now at just on the cusp of every 2 weeks because we have enough confidence that things are moving forward. But for example, we brought to that table the matter of how we are going to open our courthouses across the province safely. My colleague mentioned 70 locations for provincial court. We sit in 13 across the province, and they are now reduced to, in fact, folded into 4 hubs for the time being, pursuant to a pandemic response plan that was created by a team on our court that has been busy throughout this pandemic. So the 4 hubs, Edmonton, Calgary, Red Deer, and Lethbridge. And it's been really, I think, an effective way for us to plan as we expand out. In terms of library resources, if we were talking about from the perspective of the bar, they're very well advanced, I think, in accessing remotely resources. We have been able to do so as well on our side of the fence, because certainly we were all outfitted with computers, and our staff as well. Our legal counsel are working remotely from home. We have students coming in. Unfortunately, given the current situation, we had to back up their entry into our court to August, but we're looking forward to having them with us in some way, virtually or in person on a limited basis. So it's been lockstep with the directives of the Chief Medical Officer. So as we expanded, or as the ministry, the government, and the Chief Medical Officer moved to that stage 1 of recovery, we were able to open our doors a little bit as well. And I think that we're looking forward to stage 2, but we can't get to stage 2 without the appropriate screening, social spacing, and sanitation protocols for our courtrooms and our courthouses.
Thank you very much. And the same question to Judge McLellan, please.
Thanks. I'm just going to touch briefly a little bit on some from the question before, because I'd like to point out that we are rolling out Webex for virtual court appearances around the entire province. And, you know, we're very thankful to be able to do that. Some JDR, judicial dispute resolution hearings, are being done by our family judges on this very platform, Zoom. Judges are learning how to actually conduct them remotely. And that has unique challenges in learning how to do these matters, controlling, over-talking, engaging partners, and things like that. Civil Division is holding pretrial conferences and hopes to hear simplified trials by Webex. That program is ideally suited to Webex because there's the pre-advance filing of trial statements. We also worked on new technology for a digital warrants pilot in Edmonton that's been quite successful. All applications for search warrants and other judicial authorizations sought by law enforcement are submitted and processed digitally through a highly secure technology platform. The court created a digital judicial authorization rule of court, which allowed this pilot project to continue. So I did want to touch on those things that we are particularly moving forward. Now, if I share our experience working with administrative services, I would be echoing much of what Justice Moreau has said. We attend the Scrum meeting that she referred to. And once again, I'll focus on the fact there's been a great deal of collaborations, means a lot of meetings remotely. On a personal basis, I will say that I miss the coffee and muffins on in-person meetings, but working remotely certainly has moved ahead, and many of us are becoming far more adept at reading documents online and joining matters such as Zoom meetings. What's clear is that there are a large number of justice participants, and we've talked about that: judges, judicial staff, clerks, management, infrastructure, sheriffs, lawyers, Crown Defense and legal aid, cleaning staff, probation and services to help, and we have court users as well. The planning and collaboration is really important, and we are focused, as Justice Moreau said, on matters such as safe courthouses, safe courtrooms. There are many, many players. Research Counsel, our law library service, and our education manager has been very responsive to requests for assistance. Research that our chief and counsel has sought has been provided quickly, expertly, and remotely. One of our newly appointed judges, and we've had some judges appointed within the last few weeks, advised that he received excellent response from the librarians remotely. We've also had judges set up to do complicated research and analysis. We're going to be using Webex for a 2-day judicial education session for our new judges. So I think that covers what I wanted to say about the technology we're putting into place and we're thankful for, and our experience dealing remotely with all the administration.
Thank you so much. And I think we all miss the muffins and cookies and other office.
Can I expect them on my doorstep, Felix?
It's a little far for me, but I'll see what I can do. And Justice Khular, finally, the same question to yourself, please, if you have any additional comments.
Sure, I'll just add, we have been participating in the same daily Scrum meetings, and the focus is obviously the trial courts have the highest needs right now, and that's where it should be. I'll just say again, we're, in terms of how has it worked administratively for us, we have a skeleton staff in the courthouse, but 85% of our staff, including front and registry, are working at home, usually on any given day. Because of our electronic CAM system, we're able to function very effectively. And we just actually had our articling students start on Monday, and they came into the office for a bit of orientation, and now they're working remotely. So we're the system has responded well in that way.
Thank you very much. And I see that time is moving on already. So I'm going to, as the four of us discussed yesterday, I'm going to jump us ahead a couple of questions because we had some very interesting questions that I would not like to miss out on. So Justice Khular, if we could stay with yourself for a moment, please. And I'll ask you, what does opening up look like in the next few weeks or months for your level of court?
Sure. We've decided we're going to continue doing operating virtually at least until the end of the summer. And then we'll reevaluate in September to see where the waves of the pandemic are and so forth. And we do that for a number of reasons. I mean, one, it's easy for us to function in this format more so than the other courts. Secondly, we want to give priority to the trial courts for access to the resources, for instance, getting the plexiglass in the courtrooms and so forth, which seems to be a challenge. And particularly in Edmonton, we all share the same building. So if we can minimize some of the people that have to come to the building, that just again is a little bit better for the trial courts that have a lot more people coming in. So secondly, we'll be finalizing our CAM system. So we have been doing email filing till now, but we'll be opening up an e-filing portal by August 31st, which will complete our system. And part of doing that, we have, there'll be some Legal Education Society of Alberta will be helping doing some training with the bar over the summer. We have a big issue in terms of developing a policy on public access to the electronic file. I mean, now anybody can come and look at a courthouse file subject to sealing orders, but you have practical obscurity. You know, how much access do we want to let people have to the electronic courthouse file? And we've established a working group with some different representatives of the bar and the court to help us develop that policy. We are going to push ahead. The Court of Appeal has always had pretrial mediation or judicial dispute resolution. And historically, we haven't had a lot of uptake on that. And not despite best efforts in past years. So we're looking at piloting a project in the fall to help increase that. And there's certain types of cases that might be more amenable, like some of the fast track appeals we have, some interlocutory family members, family matters, or interlocutory civil matters. And the last piece that we'll hopefully have in place within the next 10 days or so is, while our virtual hearings have been open to counsel, parties, and the media, because we've been struggling in creating our technology as we move forward, we have not been able to have widespread public access to our virtual hearings. And we are testing that. There was one appeal today that was being tested with. There's going to be another appeal next week that technology be tested with. And we hope to then issue a notice to the profession about how to access or any member of the public to be able to click on a link on our website to watch any hearing. There have been two components that we're fleshing out on that. One is that we will ask counsel whether there's any confidentiality or privacy issues in any appeal hearings, and ask them to come up with a mitigation strategy of how we preserve that in an oral hearing that is virtual with, and secondly, anybody who would be accessing the public hearing will be reminded of their obligation. They'll have to agree to their obligation not to record or rebroadcast the hearings. But we hope to have that out by mid-June. So those are how we look like we'll be working forward for the next few months.
Thank you, Justice Khular. And the same question to Justice Moreau, please, around opening up in the next few weeks or months.
I spoke, Alex, about the master order process that we went through in Queen's Bench to essentially ramp down our regular sittings of the court. And I think I can tell you, quite frankly, we do not anticipate a master order number 5. We want to be fully in gear and are using the summer, which is normally a time where the sittings are reduced. We will have full summer sittings to attempt to catch up on our backlog, and we hope to be successful in doing that, at least reducing the number of cases. We had to adjourn about 600 cases between March 16th and May 31st. So that's a backlog that needs to be addressed. But as I mentioned before, we have resolution techniques that we've been trying to use effectively with the cooperation of the bar to bring matters into the courtroom to be resolved either in the civil realm by way of consent order, in the criminal realm by way of summary disposition. One of the little jewels that has come out of the pandemic I guess that silver lining that comes from the need for urgent transitional change is the family triage docket. Family law was really hard hit. And you can only imagine the backlog in all our regional centers. And people need the help of the courts. And while we did put out very recently an announcement that detailed all of the services in the community outside the court, collaborative law, mediation services, et cetera, that people could go to while we were in the situation of only hearing urgent matters. We're now up and running with a docket court, which is triaging matters into a resolution mode or into an in-writing application mode, or in the rarer case, the in-person or remote hearing. I've got to say that the in-person hearing would likely be reserved for a self-represented individual who does not have access to remote ways of connecting to the court. We know that our public libraries currently are closed. They're often the place where self-represented litigants have access to computers. So that's one of the little jewels, and we intend to continue with that well beyond the pandemic time. And apart from that, we have a real challenge with arraignments coming up of all our criminal trials that have been adjourned. So arraignments started as of Monday in some of our regional centers. Announcements are going up almost daily as to how the bar can handle these matters, so we're not creating this surge into our fall term. And we've given precedence for our summer months of June, July, and August for urgent criminal trials, those in custody, Jordan-threatened cases. On the civil side, I've mentioned that we have opened very lately our civil justice chambers and our master's chambers for more regularized hearings. But the bottom line there is they will be remote. There'll be very little in person, and that's just a smart way of dealing with the fact that the pandemic is not yet behind us. So I think that's about it for the next few months. The one challenge I'll mention is jury trials, and that's being faced across Canada. When you have the inability to congregate more than 15 in a location, you have effectively knocked out your jury trial of 12 jurors, counsel, accused, judge, court reporter, clerk, etc. So we're hopeful that as we move to stage 2, that maximum will be moved to 50, which will give us an opportunity to do a creative jury selection, probably in stages of getting people into the jury selection room. But we are hoping to have our jury trials up and running in the fall, and indeed our whole schedule of trials up and running in the fall. That's it for me.
Thank you very much. And Judge McLellan, if you could comment please also on what opening up looks like in the next few weeks or months for the Provincial Court.
Sure, thank you. The Provincial Court on the website has a document, COVID-19 staged resumption of court operations. Our initial curtailment of operations went from March 17th to May 25th, 2020, with presumptive adjournments. We continue to operate on a reduced scale till July 3rd. Now, I will say that I don't believe that means that a switch will be turned on July 3rd and there will be a return to pre-COVID days. We're not sure exactly what that will look like, but we are continuing to expand our services, and that's made clear on the website because, of course, we have the many divisions and many locations. Currently, urgent matters are still being heard. There's an expansion of services with the rollout of technology. I mentioned Webex and JDRs being held by Zoom. Docket courts with Webex are being held to include criminal out of custody matters. Crown Defense and Duty Counsel appear remotely in docket courtrooms. And there are some additional expansions in our family court to hear urgent matters and urgent family matters that even involve some in-person hearing. Each division has some information about its operations on the website. And the reason I say that is I certainly understand the overarching rules and movement of our court, but I'm not necessarily able to remember all the details that are being set forward, but we are expanding and moving forward. I agree with, we agree with Chief Justice Moreau, though, that we need to have safe courthouses and courtrooms there will be plexiglass, reduced capacity, and courtrooms and waiting areas, as well as signaged and taped off areas. It is correct that many people come to some courthouses. The number is between 10 and 11,000 a week in the Edmonton courthouse. I think that some changes the court has experienced will remain after the pandemic is over. We've had to work together to adapt, to make technological changes, and some of those changes show great promise to maximize the use of court resources and enhance access to justice. So the future is going to look different. I'm not sure how. There are some things as we move forward that we would like to see happen. We'd like to have e-filing and be able to use documents in a digital format. The ability to pay for filing fees remotely would help. These are items, of course, that have been identified by dealing with problems in a pandemic. We have in some locations a case management office where counsel are able to book matters remotely or come into court and adjourn and book matters. If this became a fully remote process, there would be fewer people needing to attend the courthouse and courtrooms until there's a substantive issue. So these are all the things that we continue to look at. PTCs right now are being done by almost all divisions and areas with judges, and that's holding, and they're being done remotely and holding great promise. Some of the judges, for example, note that it stops a rush of pretrial conferences over the lunch hour and prevents the collapse of them because judges and counsel weren't able to attend. So, you know, there's many items that we look when we open up that we think will be of great benefit. The enhanced use of CCTV is something I think we need to continue to look at. It prevents reduced stress, health risks, to people, to the accused who come into our court every day. And I know that remote court appearances by counsel has received some favorable support. And, you know, we will need to continue to look at that. It could be particularly useful for counsel to avoid traveling long distances for non-trial non-preliminary inquiry matters, maybe simply for an adjournment. We're going to consider perhaps remote appearances by a judge. I can think of one area where it might help. It could expand the access to our limited pool of bilingual judges for French trials. And, you know, remote out of summary disposition court. We're working on that as we move forward to opening up, and we'll consider all those things moving forward. The remote warrant application pilot project that I talked about, where warrants are being handled remotely, has had great success and large uptake by law enforcement agencies. We would like to consider perhaps rolling that out to the whole province. So in summary, I'd say that we're not 100% sure what opening up July 3rd will look like. We will continue to roll out matters as best we can, provide the services we can, and post on the website. That's my theme. And there's much that we will consider that we've learned from technology and remote appearances.
Thank you so much. And Judge McLellan, will stick with you for a moment if I may. And I think also, if I may, I think the word website may be mentioned here. But what recommendations do you have for counsel or participants in this new virtual world?
Now, I have not sat in a remote courtroom myself, so I went to some of the judges here who are sitting and received a very short list from them that I think is quite important. Now, I do have to refer to my notes on that. So the recommendations for counsel were to please read the material on the website. There are practice notes and protocols, documents and forms. And okay, this is for counsel. They've heard it before many times. Be on time. It's just as important to be on time in a virtual world as it is in actual courtrooms. We'd ask that counsel get familiar with the software, read the protocols. If you need to be ahead of the hearing for a practice, do it. We'd also suggest that sometimes there's a choice of participating remotely by video or phone. And, you know, some of the judges suggested that they'd like counsel to try the remote hearing. One of the other suggestions was to counsel about learning about muting and headphones and placement of camera. You know, I say this from personal experience as well. You know, try to find a quiet place, respond to emails from trial coordinators, and follow instructions from trial coordinators. Now, I'm not sure that you meant specifically those little things about a virtual world, but that was some of the matters that our judges thought that I should bring forward. We are delighted to continue to collaborate with our stakeholders, including all counsel, Crown, Defense, Legal Aid, and we look forward to hearing from them what they feel is appropriate and what works and how we can better improve our whole justice system. And that's it. Thank you.
Thank you so much. And Justice Khular, please, if you have any recommendations for counsel or participants operating in this new virtual world.
Sure. Let me start it. The virtual world is great because it enables us to continue functioning, but it's important. And I think the biggest piece of advice is we can't let the audio and the video problems hinder the process. So some of what Judge McLellan is talking about getting to the software and so forth is very important, and it's a challenge for everybody. One of the things we've done, our court has published some guidelines for assistance to counsel based on our experiences. And so if you go to the website, and it's under Visiting the Court of Appeal, we have 3 documents. One is a reference and etiquette guide for electronic hearings that contains both some technical information, but also what to do during a hearing. For instance, we do require people to gown for the hearings. Judges will be gowned. We want counsel to be gowned. This is a important, solemn process. We're still in the courtroom. We appreciate that people are at home and you might hear a dog bark in the background or a baby cry, and that happens, but to try to make it as solemn as possible. We have a second document is a quick reference card as about technically connecting to the virtual courtroom. And the third document is common technical issues, which is troubleshooting suggestions, for instance, on where do you position your laptop? What do you do with your mute button? Some little tips like don't take notes onto your laptop because the clicking of the keys interferes with the microphone. Use a pen and paper, like things what we've picked up during the hearings. Is it better to do it in a boardroom or in your office? So those are some of the things I think that hopefully the bar will find helpful. But primarily, just from an advocacy perspective, it is hard listening. There is a bit of a time lag. Diction is important, looking at the camera and the microphone, keeping your comments into short, bite-sized phrases and your ideas is helpful because it is harder to have an interaction with counsel in terms of a question and answer. So that helps a little bit by keeping things discreet and bite-sized. But I would say take your normal advocacy skills and do 2.0 and put it on turbo in terms of your focus on your argument and focus what you think really you need to do to persuade us and keep and hit those marks. Thank you.
Thank you very much. And the same question to Justice Moreau, please.
So I note from the clock above Justice Khular's head that we are really running out of time. So I'm going to take a tack on this because I think all the suggestions they've made are excellent from their respective experiences, which of course overlap in some ways with what we're living through in QB. I'd like to maybe take the tack of the support of the bar is so important to us. Firstly, there are a lot of people out there with good ideas. I would encourage you to access your organizations, whether it be in the civil realm, commercial realm, family, criminal, surrogate. Each of these areas, each of these disciplines have organizations, the CBA, I can name a number of others, ACTLA, et cetera, and committees that would be very happy to receive your recommendations, your positive ideas, because we're all going through this experience together and we're doing it with a very limited map. And so that helps us triage those suggestions if they're coming from your representatives with whom we're meeting regularly. We meet regularly. In fact, just this morning, I met with representatives of the civil bar by Webex. So I would encourage you to put your positive suggestions together. We can handle the criticism as well, as long as it's constructive, with a way of dealing with the issue that you have raised, suggested as well. And I think above all, we're all in this together in terms of getting through to the other side of this crisis. And we ask for your patience, your understanding as we do so.
Thank you very much. And as you noted, Justice Moreau, we are bumping up against the hour. If I may, there was one final question, so perhaps we could get some brief remarks on that final question, which is which of the changes the court has experienced do you think should and will remain, and any comments on the impact of this situation, for the future of the court system in Alberta? So
you're over to me, are you?
I apologize. Yes, if we could stay with you, Justice Moreau.
Okay. Well, I think I've said it often, even today, that the silver lining is the technology and the advances that we are making in that regard. And finally, to be told that we are going to have an e-filing system, it was responsive to the urgency. It's moving us forward into new areas. Counsel, I think, who are your listeners today, are pretty excited about what the opportunities are for them to do things remotely. And obviously, these are potential cost-saving measures for their clients. So I don't think I'll spend a lot of time repeating what I have said. The experience is one that we are not going to lose. We are going to go to a new normal. We are creating efficiencies that should have been created in our court system a long time ago, and we're just delighted to be able to have the ability to do so now.
Thank you. And Judge McLellan, please.
Thanks, Felix. I think I covered a lot of that. I was a little fearful you weren't going to get to that question. I think I moved in that to point out a lot of the measures that we feel have been valuable and that we may make use of in the future. So I won't cover that territory again. I do want to say that we are thankful to Counsel for stepping up as well. It's really important that everyone work to resolve as many matters as we can. And I will say that training on technology will apply to everybody, including judges as we move forward. I think there will be place for best practices and training. So thank you.
Thank you very much. And finally, Justice Khular, if you have any additional concluding remarks.
Yeah, I think there are tangibles and intangibles that will continue. The tangibles for the Court of Appeals, we'll have our CAM system up and running. Secondly, I can see, we've talked about how virtual hearings would likely have a place. As I said, we sit in both Edmonton and Calgary, but the Court of Appeal is also the Court of Appeal for Nunavut and the Northwest Territories. So for some matters, and with travel restrictions and so forth, that may be a function or a part of the future picture. But in terms of the intangibles, I think the most important lesson and what will hopefully will continue to be an impact is, on the part of the court, the bar, and government. You've seen a lot, you've heard about, and we've seen creativity, adaptability, and nimbleness. And so when forced, we can do that. And so hopefully we'll that intangible going as we continue to face the challenges in the future.
Okay. Thank you very much.
Echo that.
And it is, we are about 5 minutes past. So with that, I think this has been a fascinating discussion today, very insightful and also very, very practical and very beneficial to practitioners and beyond. I would like to extend a very sincere thanks to all three of you again for participating in this webinar, and thanks also to all of the participants who joined us today as well.
Thank you.
Okay. Thank you so much. Thank you.